All right, looks like we are recording. So we will go ahead and go on the record now. The time is 6 p.m. This is the hearing for Deschutes County file number 247-23249-MC. My name is Tommy Brooks. I am the hearings officer in this matter. Before we get to the substance of the hearing, I'm going to turn things over to Mr. DiMarzo to describe how the electronic process works.
Good evening. For the record, my name is Dan DiMarzo, Assistant Planner with the Deschutes County Planning Division. The item before the hearings officer tonight is a modification of conditions to a previously approved land use permit to change the point of access from Northeast Coiner Avenue to Northeast O'Neill Way. Tonight's hearing will proceed as follows. First, staff will explain the hearing format and how to testify at tonight's hearing. This will be followed by a brief presentation by the applicant. County has established time limits for testimony in the order as follows. Public agencies, 10 minutes. The applicant, 30 minutes. The appellant, if any, 20 minutes. The general public, 3 minutes. And then finally, rebuttal by the applicant, 10 minutes. The hearings officer can modify or eliminate these time limits as he deems necessary. Then the testimony portion of the hearing will begin. First, public agencies will present, then the applicant. Next, any persons in support will testify, followed by those in opposition. And finally, any parties that are neutral to the application will testify last. Afterwards, the applicant will then be afforded an opportunity to present a rebuttal testimony. And finally, staff can make closing comments. Tonight's hearing is a hybrid hearing with both in-person and remote participation. Before starting your testimony, please provide your first and last name as well as your mailing address for the record. For our in-person participants, if you wish to testify, please add your name to the sign-in sheet. I will use this list to call up participants for their testimony. After your name is called, please come up to one of the tables at the front of the room before beginning your testimony. For remote participants, which we do not currently have, if they wish to testify, they must be logged into Zoom or have called in using the Zoom dial-in option. When hearings officer Brooks asks if anyone attending remotely would like to testify, you will then need to use the raise hand feature to notify the staff. To do this, you will need to press the raise hand feature on your computer or your smart device, or if you've called in, dial *9. In addition to oral testimony, if anyone has written testimony they'd like to submit, please hand it to me. If you are in person, please submit the written testimony to me after your testimony. If you're participating remotely, you can submit it via email to me at dan.demarzo@deschutes.org. Hearings officer Brooks and staff are responsible for conducting an orderly hearing tonight. Any testimony or behavior which is deemed inappropriate will be addressed and may result in that member of the public being removed from tonight's hearing. Are there any objections to the format of tonight's hearing? If you're attending remotely and have an objection, please use the raise hand function. None. Seeing none, I will now turn the hearing back over to hearings officer Brooks.
All right, thank you. As Mr. DiMarzo just described, we're following a normal hearing process that's set out in the county's code, and I'm going to provide sufficient opportunity for everyone to participate at the appropriate time. I'd ask for your patience as we get through this if there's a lot or if we have technical difficulties, but we will get through it. The application is being considered through a quasi-judicial process, and I will consider only the factual evidence that is in the record. I will then apply those facts to any relevant provisions of the county's comprehensive plan or land use regulations. The standards and applicable criteria relevant to this hearing were identified in the public notice announcing the hearing. They're also set forth in the staff report. Public notice and the staff report are posted on the county's website, and they're also available directly from staff upon request. It is important that you direct all of your testimony to the standards and applicable criteria. If you believe a criterion applies that was not listed, you may address the unlisted criterion. However, I urge you to also explain why the criterion must apply and to do so with specificity so that other participants may respond and so that I can address that issue in my decision. The failure to raise an issue with enough detail to enable me or other participants to respond precludes your ability to appeal that issue to the Land Use Board of Appeals. Also, the failure to raise a constitutional or other issue relating to any proposed conditions of approval, again, with enough detail to allow me to respond to that issue in my decision, precludes an action for damages in circuit court. As I just noted, I serve as the county's hearings officer in this matter. In that role, my job is to be a neutral decision maker. Thus, while I have a contract with the county to serve in this role, I am obligated to remain impartial, and I do not represent the county's interests or the interests of any other participant. To that end, I will state for the record that I do not have any relationship with the applicant. I'm not aware of any connections that I may have to other participants in this proceeding that would prevent me from remaining impartial. I have communicated briefly with staff, but only to discuss the particulars of today's hearing and not the substance of the application. And I do not have any ex parte context to disclose. So that we can figure out how, if we need to make any changes for running this hearing, I'd like to determine, Mr. DiMarzo, how many people are signed up to testify, if any.
Just the applicant.
Okay. Well, then I think we can try to stick to the time limits that Mr. DiMarzo described. But for the applicant, if the need arises and we need to go beyond time, I will entertain a request to do so. So before we begin, does anyone wish to challenge my ability to hear this matter or to challenge the county's jurisdiction over this matter?
No.
All right. With no objections, I'm going to turn it back over to you, Mr. DiMarzo, to deliver the staff report.
Thank you, Hearings Officer Brooks. I'll now present a summary of the staff report for tonight's modification of conditions application. The subject property is located northeast of the city of Redmond, adjacent to the Crook County line. Subject property has an address of 4180 Northeast O'Neill Way in Redmond, Oregon. The property is approximately 242.49 acres in size and currently developed with one single-family dwelling and several accessory structures, all of which are located in the northern region of the property. The property is moderately covered with mature juniper trees and low-lying native vegetation. Subject property fronts northeast O'Neill Way to the north, northeast 33rd Street to the southwest, and northeast Coiner Avenue to the south. The scope of the subject application is a request to modify the conditions of approval for an existing land use decision to reflect A, that the newly created parcels number 1 and number 2, have access from northeast O'Neill Way. B, to remove all conditions of approval which require dedication of private property to public right-of-way. And C, to remove all conditions of approval which require northeast Coiner Avenue road improvement. Staff report in the record identifies a number of issue areas, including but not limited to: is the subject modification of conditions application an inappropriate substitute for appeal? Has the applicant obtained ODOT access permit approval? Do the standards of DCC 17.48.210B apply? And finally, do the conditions of approval and findings that the county made within the final land use decision, those which required road improvements and right-of-way dedication, provide an essential nexus and rough proportionality to the approved partition? All record materials are published on the project website, which is shown on this slide. Staff is now available for any questions the hearings officer may have.
Thank you. I don't have any specific questions at this time, so we can proceed to the next phase. You indicated no one else was signed up besides the applicant. Does that mean there's no other agency comments either?
To correct that, we do have ODOT here as a public agency representative.
Okay, thank you. Then let's have ODOT come give their comments first.
Good evening. My name is David Natowski. I'm representing ODOT tonight. My position title at ODOT is Region 4 Access Management Engineer. do you need my mailing address in the record? Okay, it's 63055 North Highway 97, Building M, Bend, Oregon, 97703.
My name's Quinn Schubert. I'm representing District 10 ODOT. My official title is Permit Specialist. I have the same mailing address. I can repeat it if necessary.
Okay. So I'd really just like to clarify, in case it's not obvious in the staff report, but ODOT had issued what I'll call outright approval of highway access on February 23rd of this year, and realized 4 days later that we had made a mistake. We had sent the wrong approval letter. The letter we sent on February 23rd was an outright approval. And 4 days later, on February 27th of this year, we retracted that letter and issued a conditional approval. Basically, the conditional approval means the application for access is approved, provided the applicant also get land use approval from the local jurisdiction, which is Deschutes County. So if the county goes ahead and denies the current application for the modification of approval conditions, then the applicant would not get highway access because he didn't meet the one condition of approval. However, if the county does approve the application at hand, then he would get approval from ODOT and we would issue a permit after the highway connection is constructed. Do you have any other questions for ODOT?
I do have one question just based on sort of how things are described in the staff report, and then some of the comments to that we received from the applicant. But I guess it raises the question of whether or not, or I guess the standards that ODOT applied when it issued now this conditional permit, and the significance, if any, of alternative accesses or access that the property might have, and whether or not that plays a role in ODOT's permit approval. Is that something you can address?
Sure, absolutely. So when we receive an application for access, we do not require that the applicant submit a burden of proof. We write our own staff report. We call it findings of fact. It's in the staff report as an exhibit. I don't remember the exhibit number, but I had stamped the findings of fact. My engineering stamp is on it. We write findings of fact for our standards, and we have 3 standards. One is for approach spacing. We call any private connection or public street that connects to a state highway a highway approach. So we have spacing standards for the nearest approaches on the same side of the highway to the right and to the left. We also have a standard for intersection sight distance. So that means when a vehicle is stopped at the approach, looking to turn left or right on the highway, can they see far enough to the right and to the left to make a safe turn onto the highway? That's the sight distance standard. We have a 3rd standard we call channelization. That's just a fancy name for left turn lanes and right turn lanes, whether or not they're required. So this particular application met all 3 of our standards. It met the spacing standard, met the sight distance standard, met the channelization standard, and that channelization was not required. So it means the site wouldn't generate enough traffic for us to require a turn lane. We also write findings of fact for 6 safety and operational criteria. They include weaving on the highway, queuing on the highway, the historic crash rate on the highway, something we call SPIS, which is another way of reporting crashes, and then potential turn conflicts from approaches on the opposite side of the highway. There's a 6th safety concern that does not apply in this application, but we didn't have any safety or operational concerns with the application either. But this application is subject to a higher bar than a lot of other applications, and that is the request was for a second or subsequent approach in a rural area, because the property already has one highway approach kind of on the northeast corner of the property that serves an existing single family home. So that's their first highway access. The bar is set higher to get a second access in a rural area. We have to consider the reasonableness of the first access as alternative access. We wrote findings of fact with the first highway approach serving the single family home being the alternate access. And our determination was that that first highway access was not adequate to serve the economic needs of the property, to serve the two new lots that were partitioned off in the southwest corner of the property. It would have involved constructing a new driveway more than half a mile in length across rough topography that includes some rock outcroppings, pressure ridges, ravines. We felt that that was not reasonable, and we were okay with providing a second highway access, again, because it met our three standards for spacing, site distance, and channelization, and we had no safety or operational concerns. But I would like to point out that there were a couple of mistakes made along the way. As I mentioned, when we issued the approval letter, we had issued the outright approval when it should have been a conditional approval. And the reason it should have been a conditional approval is because the applicant didn't have an approval from the county yet. So when someone applies for access to a state highway, we like them to get their approval from the local jurisdiction first. However, we can process our application simultaneously as the local jurisdiction. If we reach our decision first and our decision is for approval, we will issue a conditional approval with just one condition, and that is that you also get approval from the local jurisdiction. But a mistake was made early in the process because we deemed the application complete when we really shouldn't have. So we coordinate with the local jurisdictions because part of our application is called the Land Use Compatibility Statement, or LUCS, L-U-C-S. So the local jurisdiction fills out the LUCS and it asks on there, does the proposal require land use review from the county? Yes or no? The county filled out, yes, it requires land use review. The next question is, if review is required, has an application been submitted yet? The county had checked, no, an application had not been submitted. So we should not have deemed the application complete because there wasn't an application in process with the county. But in our defense, one of the reasons the mistake was made and the application was deemed complete, we had some new staff working on the application who made a mistake, but also the applicant had submitted a second version of the LUCS, the Land Use Compatibility Statement, that he had filled out himself, which said that he already had approval from the county. And he even cited the 2021 application numbers, the county's file numbers, and submitted a site plan to us that showed highway access at the desired location, and it says approved. So I don't know if there was intentional or unintentional intent to mislead us, but the site plan that was submitted to us was not the same site plan that was approved by the county in 2021. The site plan approved by the county in 2021 showed access off Coiner Avenue. The applicant submitted to us a site plan that showed access off the highway that said approved on it. So we thought he already had approval from the county for highway access. The other thing that I think may have been maybe intentional, maybe unintentional, that the applicant misled the county. When he filed his application with the county, he submitted the outright approval letter from ODOT dated February 23rd, which we had retracted 4 days later and sent the conditional approval. So again, I don't know if that was done intentionally or unintentionally. Same with filling out the land use compatibility statement. Our applications aren't always real intuitive to lay people that are applying for the first time and only time in their life. Even sometimes the local jurisdictions have questions or confusion on filling out the land use compatibility statement. But again, we had two versions of the land use compatibility statement. The one filled out from the county, which said land use was required and the applicant hadn't even applied yet. And then the one provided by the applicant, which said he already had approval from the county and cited the 2021 application numbers, which were for a completely different site plan.
Okay. Thank you. That's really helpful information. I guess is just kind of one fine point on that. If I was tracking the standards that ODOT applies, and as you're kind of going through the list, The alternative access that you're considering is the access that the property already had to the highway, and whether or not there are other, I'm not trying to put words in your mouth, but if there were other accesses from the property that could eventually get to the highway, that's not what you're looking at. You're just looking at that the primary and then the request for the secondary access on the highway itself.
We can look at other accesses besides the direct highway access. So as you know, Coiner Avenue borders the property along the south side. That could be considered alternate access,
Okay.
but is it reasonable? So as you can see in Cody Smith's comments, the county engineer, he says the right of way is substandard. It's 30 feet. It should be 60 feet. And the roadway is unimproved currently. I made a site visit and looked at Coiner Avenue, the right of way for Coiner Avenue, and it's not passable by a passenger car. It's not cleared. It's got brush, it's got trees, it's got elevation changes. So in our rules, when we consider the reasonableness of the alternate access, we consider, is it reasonable or can it be made reasonable? And we didn't think it could reasonably be made reasonable to serve the two new lots in the southwest corner of the property. We thought it was disproportionate to the use that it would get to make that kind of improvement. So we really just considered the first highway access as the alternate access, and we wrote findings of fact for reasonableness, whether the first highway access could serve the two new parcels. And we said it was not reasonable to serve the two new parcels. And we were okay with providing the applicant with a second highway access. He just needs to meet that one condition of approval, that he also get approval from the county.
Okay. And sorry to keep you up here one more time. So that just leads me to one more question. And this is helpful in understanding kind of the standards that ODOT applies versus what the county is applying in the land use context. But in your consideration of whether or not Coiner Avenue is reasonable, would you have known that the applicant was, at least at that time, had a condition of approval to improve that street or that access road, or were you just looking at it based on what's on the ground today and if kind of in a vacuum from ODOT standpoint?
I don't believe that I knew he had approval from the county for access from Coiner Avenue at the time we were processing our application. Our staff report actually says that he had been denied access to Coiner Avenue, which again could have been a misunderstanding, but I don't believe I was aware he had an approved application for access to Coiner Avenue with conditions of approval that were not acceptable to him.
I can speak to that a little bit
Sure.
too. I was more on the front lines on this one. So I think initially we had thought incorrectly that he was denied. And as the application progressed, we learned more. And we did learn that that the county had allowed him to use Coiner Avenue. I think there was still some confusion there about what the conditions of approval were. I was under the assumption, or not the assumption, I had the information that the whole frontage would have to be dedicated and improved. This could have just been a miscommunication, but that is the assumption that we were working with. And like I said, the application had already been received at that point.
Thank you both, gentlemen. I don't have any further questions.
I would just like to close by restating what I stated at the beginning, which is the applicant currently has a conditional approval from us. One condition needs to be met. He needs to get approval from the county. If the county denies his application, he won't have a second highway access, and we're okay with that. If the county does approve his application, he will get a second highway access, and we're still okay with that.
All right. Thank you.
Okay.
I don't think there's any other agency testimony, so we can have the applicant come up, or the applicant's representative.
Lisa Andrak for the applicant, Fichineri 210 Southwest 5th Street, Redmond, Oregon. And I wanted to apologize for the late submittal of my supplemental burden of proof information and exhibits today. I only received the staff report Thursday, and by the time I got to it, it was late Thursday or even early Friday morning by the time I got a chance to look at it. So I apologize for late submittal. I didn't mean to send everything in at the last minute. But I wanted to kind of parse through some of the history of what's happened here and respond to some of ODOT's comments on the application process. So the application for the partition was initially proposed to take access off of Northeast 3rd Street and then to have a shared access easement that would run along the side of the southern border of parcel 1, so that parcel 2 would have access via that access easement, and it would run along adjacent to the Coiner Avenue right away. However, the proposal in the site plan was so that the access would be, the easement would be located on the private property of parcel 1. And I think there may have been some confusion with that site plan, which the county didn't particularly address. Northeast 33rd Street and any proposed access there. It was just a decision with the conditions of approval that the access would be from Coiner. And then with the dedicated right of way, the length of the street of Coiner, which I think is about a mile long. So a 1 mile long dedication of right of way. And then with also road improvement standards with aggregate and a bulb cul-de-sac turnaround at the terminus of Coiner, so that there could be a turnaround, because Coiner right now dead ends at the Northern Unit Irrigation District Canal. So it literally goes to nowhere. There's no bridge or any other means of crossing the irrigation canal, which then if you did cross the irrigation canal would lead you into Crook County. And on the other side of the canal are properties in Crook County zoned for agricultural use. So there's really, Coiner is really a road that goes to nowhere. The applicant had proposed the access off of 33rd Street, and the road department didn't really comment on that access, but just jumped right into taking the access from Coiner. However, it became clearer through correspondence with the county. David Doyle sent an email and said that access from Northeast 33rd Street was not possible. It didn't meet the distance requirements of the county code, I guess. So that is, I guess, why the road department did not consider that and then just required the access from Coiner. So after receiving the land use approval, the applicant was represented by a land use consultant at the time. And the time period for appealing any of the conditions of approval or the issues about the access had expired. And in consultation with me, it wasn't clear that the county denied 33rd Street as an access option, even though it had been proposed. It looked like the county just required all kinds of dedication and improvements to Coiner. And so it seemed like the county had misread the site plan that was proposed, the partition plot proposed, so that the easement was actually looks maybe like it was intended to be a dedicated right of way, which it wasn't. So I made correspondence with the county, and then following that correspondence was directed to get access from ODOT and go through the Lux process and everything else. And so that really does bring us here to today. So what we are asking for is a modification of the conditions of approval in the original land use approval to allow for the access to be changed from what was originally proposed, which was Northeast 33rd Street, or what the county approved as Coiner, to allow access from O'Neill Highway. So O'Neill Highway's improvement apron would be a lot less onerous on the applicant, and then the access could easily be provided to both parcel 2 and parcel 1 at the location approved by ODOT, conditionally approved by ODOT. So the applicant is making a discrete request to modify the application. There's no changes to the number of parcels, the size or shape of the parcels, the locations of anything else. It's simply just the access, and it's simply based upon the applicant never really proposed access from Coiner. It's just something the county imposed, and then with an obligation or a suggestion too, that if they could get access from ODOT off of O'Neill Highway, to go ahead and move forward with that and then come back in and do the modification. So in the staff report, I'm gonna follow a little bit about a little bit of what I put in the supplemental burden of proof. And I know you got that late today, so maybe this will help. If you have any questions, we can also address those at the same time. But so to the east of the property, there really is no future development that would be served by creating Coiner as a full width 60-foot right of way, dedicated right of way and improved street. There's the NUID canal that creates a boundary at the end of Coiner's existing 30-foot right of way. And to the east of that is Crook County ag zone properties. And so those would be hard to develop. And if they could be developed, it'd be minimal development. And I'm sure at that time, Crook County would require that those parcels be developed in such a manner that it uses the public roads that are already available or would be created by that development. And that those parcels also have access to O'Neill Highway. So they would have the means to get access in other ways other than by using Coiner, which would have to cross an irrigation canal and then provide, access that is to farm properties. So there's really no potential development to the east that Coiner would serve. So it was a little perplexing as to why the county might consider that there is future development potential that warrants the need for the dedication and any improvements to Coiner. To the south of the property, again, it's about a mile long, I think, for the southern border of the property. There's already that undeveloped right of way. It's identified as that on Exhibit 1, 2, and 3. And you can see in Exhibit 2 that the property to the south, which is in the Lake Park Estates subdivision, is already developed with residences on those lots. I think every single one of them has already a developed residence, and they take access off of Northeast Butler, which is to the south of those parcels. So as the representative from ODOT stated, nobody's using Coiner for access. All the access that is necessary and that was required for the residential development in Lake Parks Estate is already it's already been developed, and those lots are already using the existing roads within that development. So nobody is going to develop their property in Lake Parks Estate such that they would need to take access from the northeast corner road. If there was an occasion where there was a need to improve Northeast Corner Road for some future development of any of the properties adjacent to this, either to the east or to the south, then at that point, since the applicant really has no benefit for Coiner's improvement or dedication, if it needed to be improved or dedicated at that time, the county would still have the authority to make that happen, but they would need to acquire the dedicated right of way through the inverse condemnation process, not through this application where the dedicated right of way for Coiner serves no purpose to the proposed development, a 3-lot partition. If the Crook County was wanting some future development to use Coiner for access, again, there's the eminent power of domain, and inverse condemnation could be made and just compensation paid for the dedicated right of way. Of course, any improvements that would be required for Coiner would also then need to be paid for by the public, who also benefits from that improvement. It shouldn't be shouldered on the back of the applicant here just in order to do a 3-lot partition when he has a feasible access from the highway and can avoid the expense of these improvements and, of course, the extensive dedicated right-of-way requirement. Even if the county code requires dedication of the right-of-way, as is being insisted upon here, it would still constitute a regulatory taking. And the same is true with the prohibition to use O'Neill Highway that I believe Peter Russell was relying upon in Deschutes County Code 17.48210 sub B, that there's a prohibition on using the arterial if there's another source for access, because there could be a very safe and reasonable access from O'Neill Highway relying on 210 sub B to deny the right to use the O'Neill access in favor of Coiner would be a constitutional regulatory taking. And just because it's in the code doesn't mean that it's exempt from a taking analysis. And so if the county is going to impose such a taking of the property, notwithstanding the opportunity to get approval through ODOT, then there needs to be an analysis which has not been met in this case at all. Peter Russell says that in the original decision on page 5, and he doesn't address Northeast 33rd or Coiner either. In his comments originally for the land use approval in the decision on page 5, he said the applicant will need to obtain access permits from ODOT and provide copies to the county. So in his initial review and comment on the original proposal, it's not clear why he was even talking about ODOT, but he obviously had contemplated access from ODOT and via O'Neill Highway. And so at that time, if sub B applied here, Peter should have acknowledged that, made a statement, and would have not made the same comment that ODOT would, get permits from ODOT and provide copies to the county, because he could have and should have stated access from ODOT would not be approved, it would not be allowed pursuant to 210 sub B, and then made that clear. Now, instead, the original decision doesn't even address 210 sub B as an independent necessary criteria to satisfy. Peter doesn't address it at all. In fact, he says just the opposite of what he's saying now is go to ODOT and get access and then show us your permits. Now he's flipped on that and is relying on 210 sub B as a regulatory restriction in order to say that you can't use ODOT access and therefore acquire a dedicated right of way up to a mile long and road improvements. And he does so really without any explanation or justification. And his comments contradict all the communication that's been happening with Deschutes County since the land use approval initially. So first, like I said, I wasn't initially involved. And the county had correspondence with the applicant that said, go to ODOT and get some permits for access and then come back and do a modification of your approval to address the changes in the conditions of approval. Or if you can work with the road department to modify the conditions of approval for the dedication and the improvements, then do a modification application and come back in and modify the conditions of approval. So the applicant, I had the same conversation with David Doyle, and he again referred me to planner Tarek Rawlings' email that said, negotiate an access or get one from ODOT and then come back in and do a modification. ODOT did, as they stated, analyze the access issues for the subject property and the proposed partition lots. And exhibits 17, 18, and 19 that I submitted today are all of the communications received from ODOT regarding the access. I don't think there was anything nefarious about the initial application with the Lux or the documents sent to the county concerning the ODOT application, because the county was specifically provided exhibit 19, which is ODOT's second letter regarding the approval. Haley King was copied on that letter, and it was sent directly to the county. And the first page of the letter says, we're providing the county information about this conditional approval. We're giving them a copy of the letter because we're required to coordinate by our administrative rules with the county regarding access. And so the letter was specifically sent to Deschutes County. There was also communication between Haley and ODOT's permit tech regarding the need for the applicant to modify the application conditions of approval once ODOT made a decision on the permit. So there was nothing secret, there was nothing nefarious about what was being sent to the county or concealing any kind of information from the county in any way. The county had full knowledge of everything. The initial Lux application, it was filed with the county, and then the county returned it, and then we sent in a different one because the ODOT had updated the form, and so we filled out a new form and sent that into ODOT or into the county for approval of the Lux. And I'm not really sure what the language on the form is, but nobody was trying to hide anything from anybody. It was just filling out the form as best as I think was understood at the time. But in any event, the county was very clear that if they approved the Lux, they stated it the first time the Lux was submitted, and then they rejected or returned the Lux and then required a second application. So when we did the second application, again, we were reminded of the same language and a reiteration that if the county approves the Lux, it will be conditioned upon the applicant then coming back and doing a modification of the conditions of approval in order to change the access requirements for the partition. And we had to agree to that process before the county would even sign off on the Lux. So the applicant agreed to that process as part of the Lux process. And initially, when the Lux was submitted to the county initially responded with, you shouldn't be doing a Lux, you should be doing a modification of your application. We didn't want to do the modification first, because then if ODOT didn't approve the access, then we'd have to come back and modify the application again in order to fix the access again. And so without necessarily that change in circumstance, we didn't have an ODOT permit in hand. So we really couldn't just go modify the permit approval, relying on an ODOT access that we didn't have. And therefore we also didn't have a change in circumstance. So it didn't really make sense to do the modification first. So we went through the Lux and then the ODOT permit process. And then we're in agreement and correspondence with the county at all times that we would come back and do the modification after ODOT did its review and approval of the access. The proposal is a modification. It is a change in circumstances. It is addressing specifically a change in the location of the access. Subject to, the ODOT approval, and they have some of their own development standards that will have to be met, which the applicant will do. It's not an access that could have been originally addressed in the original application. We didn't have a decision from ODOT. We didn't have a permit from ODOT or anything that we could rely upon as a proposed access in the original application. And it didn't exist at the time of any appeal period either. So it's not something that could have been raised and addressed in the original application. Although Peter Russell touched on it on his own, he didn't analyze it, and it wasn't something that was proposed by the applicant. The county now alleges that this is somehow a collateral attack on the original decision. And this again is completely deviating from any of the correspondence we've ever had with the county about this process and what we should do to move forward to change the access. It's not a collateral attack. That Lane County case that is cited by Peter Russell says that, you know, if you're trying to address the procedural or substantive issues of a decision that should have been addressed through an appeal, and now in another application, you're trying to address those same issues as an attack on the substance or procedural findings of the county, then that would constitute a collateral attack. Here, all we're doing is asking for a change in the location for the access, and which then negates the need to do any improvements or any dedication to Coiner. We're not attacking the county's original decision about why or how it decided about 33rd Street or Coiner. All we're asking for is that the conditions of approval that are negated by the new access just be removed. In an email before we even started this entire modification or ODOT process, I had emailed David Doyle, Adam Smith, and a number of other people that you can see on the email thread, asking them specifically, is the county going to oppose the applicant coming in with an ODOT permit? Is their county going to oppose a petition or an application to modify as a substitution for an appeal? Because I know that that's something that comes up in these modification of applications. And so I wanted to address that issue up front. Where's the county standing on that issue? And David Doyle was very clear. He sent an email, point number 1, yes, it is the county's position that an application to modify the condition of approval is not a substitute for a timely appeal of the underlying land use decision. And that is exactly in line with what I think the planner said when he gave us information about submitting for the modification when he first tried to reject the Lux, saying all you're doing is modifying the access point. It's a change in circumstances. So you should not go through the Lux first. You should go through the modification first. I've had several correspondence with the county, all addressing the modification process. Then David Doyle's email also says, point number 4, if your client now wants to modify the application to take access from O'Neill Highway, a state highway, the requirements for improving Northeast Corner Avenue along the frontage of the parcels could be removed, subject to getting the ODOT approval. So we move forward with that process, and that's why we're here today. And in fact, the road department has agreed that now that the access is being relocated to the state highway, there isn't any need to do the improvements to Northeast Corner. However, what they're still trying to do is get the dedicated right of way. So it would be, again, another unimproved dedicated right of way that goes to nowhere. The applicant has spent, based on the reliance on the county's position and information and direction on the modification, the applicant spent considerable time and money. He's invested into this now. And then the county comes back and without explanation changes course. So an exaction can be in the form of a physical taking of property. It can also be in the form of requiring an applicant to spend money. In this case, it's almost like the county is just kind of running the applicant around to, I don't know what the purpose would be, but, making him spend money and time doing things, acquiring access permits from the county or from the state, and then doing a modification application here, and then just blatantly wanting to reject it with information and now a new position that's completely contradictory to everything else that's been said on this application and without explanation. And it doesn't pass the smell test. And there's some pretty strong language used by the Supreme Court when government tries to take an exaction from someone in order to avoid actually having to pay for what it wants or following the rules and regulations that are required of it. And I think this case really does give rise to some suspicion as to what is the intent, what is the purpose, what are we doing here? I mean, this is almost the facts in the situation scenario here is almost identical to the situation at hand that the court analyzed in Dolan versus City of Tigard. That is a case from 1994. And I know you're familiar with it because it's the first thing that you learn about. Well, the second case you probably study in law school in Constitutional Law 101 about takings. And here the facts are almost identical. In that case, the government was requiring somebody to put in a pedestrian bikeway and walkway. And they were requiring it as an easement. Here, we're requiring an actual dedication of the fee simple title to the property. The court was very clear that that constitutes a taking of property. And if it's going to be for a public purpose, you have to have a nexus demonstrated as to the relationship between the requirement for the dedication or the improvements and what's served by the public and what the development is imposing on the public or the surrounding properties through impacts or burdens. And here there's no impact or burden by the proposed relocation of the access to O'Neill Highway, and there's still no nexus analysis. There's no rough proportionality analysis, and this has been the law of the land since at least 1994. It just flies in the face of what the well-settled law is. I really was shocked that we were having this argument in this hearing about a required dedicated right-of-way when that issue is well settled. There's nothing proposed by this application that triggers any kind of burden or impact on the surrounding community. The county never appealed ODOT's decision if it felt that ODOT made a mistake in its decision that somehow the access wasn't safe or that ODOT was operating on misinformation. The county could have appealed or challenged ODOT's decision and it didn't. And it's over a month old, so it's pretty well settled that I think the appeal process is passed. The safety issues never been raised by the county or Peter Russell before. And without going through the constitutional analysis, Deschutes County cannot require the applicant to dedicate right away. And what's important in the case law too is that size doesn't matter. So it doesn't matter how much money is being required of the applicant. It doesn't matter how much area, square feet, or what it is. It's if the county is requiring from a private party something for the public benefit that doesn't meet a nexus or rough proportionality analysis, then it's a taking, and it can be a small taking, it can be a big taking, but it's still taking. And so the only thing that matters there is the amount of the damages. So with that, I really don't have anything further to add. The legal analysis of the case law is in my supplemental burden of proof. But I really don't think that the county has met its burden here to show any kind of justification for the continued requirement to dedicate the right of way. And I don't believe that 17.48210 sub B applies here. And I think that's true too, because not only does the county admit the state has exclusive jurisdiction of the access issue if it's a state highway, there is still, even if it's preference is for arterials not to be used, there is an exception within there if the other right-of-way available is not possible. And here the county said 33rd Street is not possible, and the improvements required for Coiner aren't justified. So with that, I don't really have anything further to add unless you have any questions.
I do have several questions. I'll try to make them make sense in order, but it might be a little bit in reverse of how you presented things. I think you probably answered this as you wrapped up your comments about the sort of the constitutional issues, but I just kind of want to be clear. Your issue about the nexus, that's relevant only if the modification is approved and if the dedication and improvements to Coiner are still required. Is that right?
Right. If the dedication is still required, like as being like staff recommended or Peter Russell was recommending. I think the road department also was recommending that. If the dedication is required, then I would say yes, that is not, there's no nexus showing that that's required. And I believe the road department agreed that without the use of Coiner, then road improvements weren't necessary. So, but if road improvement requirements were also imposed or continued to apply as a condition of approval, I would say that also then needs to have a nexus rough proportionality analysis.
Okay, and the reason I ask is because some of your comments spoke to the, I don't know, maybe the prudence of improving Coiner even as part of the underlying application. But that, to me, since that decision's been made and is acknowledged as not appealable, I think the constitutional issues only apply as we move forward, if that's done. So I just wanted you to have the benefit of kind of how I'm trying to frame up the issues that are before me. Let's see. To that end, sort of working backwards still, you also have stated that the provision in the code, the 1748-210B, which imposes access restrictions and limitations, you're saying that that does not apply. And as I read it, it refers to arterials, and if the county's TSP and other documents refer to ODOT highways as arterials, it seems like it does apply. And then the question only is whether or not there is no other possible means of accessing the parcel. So I kind of heard you say a couple different things, and I wanted to understand what the applicant's position is does 1748-210 apply, or just as applied, it doesn't get tripped here because you think that there's no other possible means of accessing the parcel?
I would say first, it's the position that it does not apply, because it's concerning access restrictions and limitations. And here, Deschutes County is not issuing an access permit. Deschutes County is not making an access determination. They're not looking at it for safety, traffic flow, sight distance, and all the other regulatory issues that they would look at it for. So they're not reviewing an access for and then putting restrictions and limitations on it. So our position is that the 17.48.210 access requirements don't apply. If A doesn't apply, which is what Peter Russell said, I find it hard pressed to say that B does, because how can the county further restrict an access that it's not even permitting? So I would say, parsing through the code, it would look like B also does not apply. So those look like standards if the county was actually issuing the access permit, and it's not. So in the alternative, if the access requirements of sub B do apply, then relying on that as a regulation to prohibit an otherwise safe and efficient, feasible access off the O'Neill Highway would then constitute a regulatory taking. And again, it would require a nexus analysis with rough proportionality and all the other factors that might go into, and actually, I think more than that, it's a Penn Central analysis of, what is the economic impact and the other factors that go into an analysis for the regulatory taking there.
So I understand your answer on, or at least your argument that 1748-210 doesn't apply at all. I'm not sure if I agree. I'll just give you a heads up on that, just because I think it's part of the subdivision requirements that were applied by the county, not necessarily independently of restricting access. And it was part of the overall analysis in the subdivision. But we can still get to if we then go to whether or not that limitation applies. I'm not sure I was tracking what you were saying about what the off ramp is from this, if it does apply, and whether or not there's other possible means other than trying to speak to it in terms of improper exactions. But don't I have to assume that there is another possible means of accessing the parcel? Because it was part of a decision that concluded access would happen from Coiner, and that decision was not appealed.
Well, the county imposed it. So I don't know that you can just make an assumption. I think ODOT's comments were that it really is not improved. It's not really accessible at this point, and it would require considerable work to the point where it almost isn't even reasonable. So under sub B, if it does apply, then I think it has to, I mean, how can the county, when it has no jurisdiction over an access permit, condition an access permit? So that sub B would be a restriction and limitation on any access permit. And the county admits they have no jurisdiction over it. And then the language then says, okay, so if it's it says the creation of the access onto arterials and collectors is prohibited unless there's no other possible means of accessing the parcel. And at this time, 33rd Street's not an option, and Coiner would be considerable work. So I guess then you have to determine what does possible mean. And I don't know that that's defined in the code. So I would submit that using Coiner is not possible, and the cash outlay to do so is substantial. So it require all kinds of improvements just to get to be able to use Coiner. So is it possible? Does possible have a reasonableness factor to it? I would submit that it does. And so again, it gets back to the analysis of, the nexus and the rough proportionality. What's being required of the applicant in order to use Coiner, just so that we can say that he can't use something that's otherwise available to him. Again, it's a regulatory taking. Just because the code says it doesn't mean that it has to apply.
One of the comments you made was that the access from the highway could not have been considered in the underlying application, and I wanted to push back on that. Why could that have not have been considered in the original application?
It wasn't proposed. And so the proposal was not to use the highway. So the modification of an application, I believe the criteria says that it has to be a modification of a discrete aspect of the application. Oh, so you're talking about the collateral attack issue and why it's not a collateral on the original decision?
That may have been the context you brought it up in, but as it's reflected in my notes, the comment that piqued my interest was that you were saying that, and I think that is probably more about changed conditions, the component of this rule or this provision, where you said, what's changed is that the access is now available from ODOT, and that it couldn't have been considered in the underlying subdivision application. And that sounds new to me because in the land use world, we often, just because a regulatory permit has not been applied for, doesn't mean it can't be made part of that application, subject to a condition of approval of going to acquire that permit. It happens in the environmental permit context. It happens as described by ODOT. It happens in their context. The fact that they can even give the Lux and the conditional permit from ODOT kind of go hand in hand, and is circular. And I'm sensitive to the fact that developers sometimes get caught in that loop, but it's more of a regulatory choice. So what I heard you say though was that you couldn't have considered the ODOT access as part of the original application, and now that it has been considered, that's the change in conditions. And I'm trying to flesh out what the basis for that is.
Well, the applicant didn't have anything from ODOT conditionally approving, tentatively approving, or considering this access at all. So where the access would have been on the highway, or would ODOT have even considered it, based upon all of the 6 points that they have to go through, it seems like, anything speculative could be, or, there's any number of things I guess an applicant could then feasibly have considered in an initial application that then someone could say would preclude them from later modifying conditions of approval, because that was something in the realm of something they should have considered, like access anywhere along the frontage of O'Neill Highway. The parameters, though, is that the applicant did not have any indication from ODOT or any information that he was going to have any access or use O'Neill Highway. And if he did, then that probably would have been proposed. But here, he was proposing Northeast 33rd Street. That was what was the facts, the substantial evidence in the record, and that was what the applicable criteria were analyzed against. And so with that, I would say the applicant that was not a factor of consideration in the original application. I don't know why Peter Russell made a comment about it, but he did. But he didn't explain it. So I have no idea what he was talking about. The applicant certainly did not propose it. It's not in the application materials. So it wasn't something that was proposed in the original application that was somehow denied, and now we're coming back and trying to do it again. Like I've seen other decisions, one of them I cited too in this case, where somebody was trying to change the landscape screening that was required, or the landscaping ratios and other things like that. And it was something they were now saying there was a hardship and other factors. And the analysis in that decision was that those are things that you could have considered during the original application and made comments on or proposed conditions and adjustments to. Here, there's a lot of what ifs and what could be's, but none of those were a part of the application, and that they weren't the subject of what was being reviewed in that application.
I guess the reason I ask, and it might be something you want to provide additional argument on, is I think that granted, the applicant may not be able to consider everything, and every hypothetical probably shouldn't be used as a reason to not be able to get a modification. But where I think it gets to the heart of the issue is what circumstances changed, and is that a circumstance that was in the control of the applicant versus a circumstance that was outside the applicant's control, because I feel like that's a meaningful distinction in the code. You may disagree, and I would like to hear your opinion on that. But if we allowed it to be interpreted in a way that any change the applicant makes that's wholly within its control is a change in circumstances, then it seems like anything would be subject or be available for a modification, whereas I'm not sure that's what the code is intended to do. Is intended to address changes that maybe weren't able to be addressed at the time, on the ground conditions that have changed, stuff like that. So if you have an opinion on that, I'd either welcome a response now or a written response later.
Well, if you look at the requirement in the code, which specifically sets forth what the modification, the grounds for filing a modification shall be, is that a change of circumstances since issuance of the approval makes it desirable to make changes to the proposal as approved. It doesn't say a change of circumstances that you had to have considered, contemplated, and submitted with your original application. It just says a change of circumstances. And clearly getting ODOT's approval for an access is a change in circumstances. There's nothing further limiting in that language. And if, again, I would say this is a significant change in circumstance. It requires a change from the location of the proposed access. Instead of just, well, we don't really want to plant that many trees because we don't have that much water, or the landscaping buffer issues, where those were required in the decision that was subject to that other case I referenced. And then they were just trying to come back and modify some of those conditions of approval about whether they should have to do plantings for screening and other things like that. Those were all criteria that were required to be addressed in the original application. And they were also subject to the conditions of approval and could have been appealed. We're not asking to just modify the road standard, the standard of improvement that the road department wanted for Coiner. the amount of aggregate, the width, or anything like that. What we're asking for is a change in the access. The change in the access is a change in circumstances. And it doesn't say it has to be an absolute, so it's absolutely something new and fresh and could have never been contemplated or speculated upon in the prior application. I think that would be pretty prohibitive for anyone to get a modification. So here, we're not asking for changes to the conditions of approval to amend them. What we're asking for is that when they're negated, they be removed. So here, it says makes it desirable to make the changes to the proposal. Here, obviously, the different access certainly makes it more desirable. And if there's more that is required by that language in order to get a modification, it's not stated in the language of the code. And there's restrictions in quasi judicial legislative making where all of a sudden there's new imposition of restrictions on what is a change in circumstance and how desirable it has to be. So the applicant has to be able to discern from the language of the code what is required. Here, it doesn't say it had to be absolute not comprehended or something that was even on the horizon when you made your initial application. It's just a change in circumstance that makes it more desirable.
Yeah, and to be clear, I'm not suggesting that it needs to be something that the applicant couldn't have contemplated. I'm more focused on whether or not the applicant can change the circumstances in order to get the modification. And that's the piece that I'm going to be grappling with. I'll give you just an extreme would be, condition of approval that requires a certain setback from a wetland, and then the applicant goes and removes the wetland, and then says, "Well, there's a change in circumstances here. I should get a modification." I don't know that that's how the code is intended to be read in terms of sort of what the ability of the applicant is to shape the circumstances versus respond to circumstances. And so it's something I will be trying to understand as I read through this record and interpret that provision of the code. Another question, I think the only site plan, so to speak, that I've seen for the new, and I confess I have not gotten through in detail all of your supplemental information from today, but I did try to go through it. But there's a couple figures that show the new access road or access point, the approach, I guess. Am I correct in understanding that the actual point of access will be from parcel 1 and parcel 3, and then parcels 1 and 2 will both need to have access across parcel 1 to get to that new approach?
No, let me find my original modification application. Is that here?
That is correct. He's correct.
Okay. Yes, you're right. So it is a location on parcel 3, and then they would have an easement for parcel 1 and parcel 2 to take access, but the access point is located on parcel 3.
Okay. I think comparing that to the original one where each parcel had its own separate access to Coiner, how is that being addressed, that parcel 1 would need access over parcel 2 and 3, parcel 2 would need access over parcel 3? I don't see anything yet in the record that shows how that would work.
Well, on the partition plot, it would be an easement for access located on the partition plot.
And is that something you've proposed as part of your materials?
I believe the easement was proposed in the original application because it was always at all times supposed to be an easement, not an actual use of Coiner. I don't know that I specifically mentioned that it would be an easement or an easement located on the partition plot, but that's what it would be.
Okay.
It would be an easement.
I think that's actually all the questions I have for you right now. Are there any other issues you'd like to bring to my attention? There's obviously not going to be a rebuttal if there's no other testimony.
I was just looking real quick at some of the decisions on modifications to see if there's any more clarity on the change of circumstances issue. I can submit more on that. If we leave the record open, so I can ask to leave the record open in order to submit more comment on that.
Yeah, I will leave that up to you if you'd like to keep the record open. Obviously, there's a mechanism to do that, and I will do that.
Okay, I request to leave it open.
Would the normal 7 days be enough for you?
Yeah.
Okay.
777.
Yes. And that's, I know you know all this, but just for the sake of everyone, because there would potentially be new evidence coming into the record, that 7 days would be reserved for other parties to be able to respond to any of that new information. And anyone in that first 7 days is actually open to anyone as well. And then the last 7 days is just for the applicant to be able to do a final legal argument. But other than that, are there other issues for you?
No, nothing further.
Okay. And Dan, I just want to make sure I don't skip anything. Is anyone signed up or logged on that we think wants to give testimony either for or in opposition to the application?
Hearings Officer Brooks, I can confirm there are no participants in favor or opposed that would like to testify. But David Nitkowski from ODOT has indicated that he'd like to present some more if you'll allow it.
Certainly, I will allow it, and then the applicant will, of course, be able to have a chance to rebut.
Okay.
Okay, thank you. Thank you. Again, it's David Natowski representing the Oregon Department of Transportation tonight. I wanted to provide 2 points of clarification. The first, in response to something that the applicant's attorney, Ms. Andrich, mentioned just before we got to the hearings officer's questions. She had mentioned that Deschutes County had the opportunity to appeal ODOT's conditional approval, and they didn't appeal. Well, our decisions are not appealable by anyone other than the applicant. If we had denied the applicant could appeal. If we had approved it with mitigation, that's an appealable decision. When we approve something outright, there's no appeal because the applicant got what he had applied for. But DOJ has told us that our decisions are not appealable by anyone other than the applicant. They're not land use decisions. It's an exercise of our police power. We even have a neighbor notification process. The applicant's required to notify the neighbor on either side of the property that they have an application in process with us. And the neighbors can submit comments in favor or in opposition of the application. But even the neighbors that submit comments do not get an appeal if they don't like the decision. Our decisions are only appealable by the applicant.
Okay, thank you for that clarification.
And then there was one other thing I wanted to provide clarification on, and that is our access management rules say if the local jurisdiction has access management rules that are more stringent than ours and allow less access to the highway than ours, then we would apply the local jurisdiction's access management rules in our applications. So as I had explained earlier, when we processed our application, we felt that Coiner Avenue was not reasonable alternate access. However, if the county believes Coiner Avenue is reasonable or can be made reasonable, and their code says you don't get access to an arterial if you have reasonable alternate access, then again, we would leave it up to the county. If the county denies the application they have in process now, again, we're okay with that. We issued a conditional approval with the one condition they get approval from the county. And if the county denies the application because they think Coiner Avenue is reasonable or can be made reasonable, and then we're okay with that decision.
All right, thank you. Yeah. Ms. Andrak, is there anything about Mr. Nastowski's last comments that you would feel the need to rebut? I don't want to open it back up to just general testimony.
No, nothing further.
Okay, thank you. So before we go off the record, then I think Mr. DiMarzo, you heard, well, let me ask you, does staff have any additional comments other than the procedural comments about leaving the record open? Is there anything substantive you would like to raise?
No additional comments outside of the open record period discussions.
Okay, then before we go off the record, then if you could provide that detail about additional submittals, I would appreciate it.
Sure. So before providing the dates, just want to confirm for clarity that the applicant agrees to extend the 150-day clock during the open record period, which is going to be 7/7/7 for 21 days total.
Yes.
Applicant agrees. So the first 7 days will culminate on Wednesday, July 19th at 4 p.m., followed by a rebuttal period, which will culminate on Wednesday, July 26th at 4 p.m. Finally, followed by a final argument, at which case the applicant only can provide testimony, which will culminate on Wednesday, August 2nd at 4 p.m. Any electronic submittals must be received by the county's email servers by 4 p.m. on the date of the deadline. Please don't wait until the last second to submit or a minute. All submittals can be sent to me, Dan DiMarzo. My email is on the screen, dan.dimarzo@deschutes.org. Deschutes County does not take responsibility for retrieving information from a website link or a personal cloud storage service. And just to reiterate, all electronic submittals must be received by the county server by 4 p.m. on the date of the deadline.
All right, thank you. I think I know Ms. Andrak understands the 7/7/7 period and the scope of that, so I'm not going to reiterate what I normally do. But just ask everyone to adhere to those deadlines if there are additional comments to be made. July 19th, July 26th, and August 2nd for the final legal argument. And not seeing anything else that needs to come before the hearings officer, we'll go off the record here at 7:21 p.m. Thank you.